Buenos días.
Buenos días.
¿Cómo estamos?
Bien.
How we doing? We're doing good, good. Welcome, bienvenidos. Bienvenidos, everyone. I'm obsessed with the bubble sound, the water sound walking in. That was a surprise for me as well. I'm not over it, yeah. I guess the Centro staff wanted everyone to have all of the experience of the senses coming in here for the Sea of Islands. We also have a song trapped in our minds, just a little ditty that we created for Sea of Islands. And so, and by we, I mean Brandon, who's somewhere here, who sang it. And I just want to say we've been working on this for a really long time. And it is such an honor to be here with you all. I'm going to read my remarks because, as you see, when I go off script, it just, what happened over there? Okay, I have things to say. Okay, so, bienvenidos everyone, and thank you so much for joining us this morning. I want to give a special shout out to Agua, Sol y Sereno. Before I say anything else, I want to mention that you saw on the fence that they put right outside, that installation will be there. The little white ribbons that you see, they would like to invite you to write your message for peace and to tie it on that fence. We are going to be all marching together at the Puerto Rican Day Parade. And with Agua Sol y Sereno and with a contingent of 150 people from CENTRO in our community. And so we're hoping to bring some of these elements with us, but also to mark this moment as we're thinking about peace and a dignified life for the peoples of our homelands and all of your homelands. My name is Dr. Yomaida Figueroa Vázquez, and I am the Directora of CENTRO, the Center for Puerto Rican Studies. Welcome to CUNY, welcome to Hunter College. I want to thank you, all of you, for moving, for moving through this process with us, for being present for that opening, for coming up the stairs with us, for standing and engaging with these beautiful artists. Agua Sol y Sereno is a theater collective based in Puerto Rico and founded in 1993. I want to thank them for that enchanting and beautiful ceremony that frames the 2 days of the panels and presentations that we're going to have. Their aesthetic and community-based work maintains a dialogue with social reality and the search for the inner poetics of the human being. They talk a lot about their work as not just theater, but also psychological work, right? It's work for the betterment of the community. The collective has produced more than 20 original plays, and their performance pieces explore art from the perspective of the street, incorporating themes of local and international relevance. CENTRO has had the distinct honor of participating in workshops with this collective as part of our Rooted in Relational retreat in Puerto Rico. And in that experience, it felt crucial to share their magical work with you this morning. So I want to thank them again for that work. And just like on the side, when we did this workshop with them in Puerto Rico, they like rocked our socks. Is anyone here that was in there? Yeah, rocked our socks. They crying, snotty tears, like it was so intense and so incredible. And one of the interesting things that happens is there was somebody walking down the street, a man with a camera who was doing photography. And then he just kind of like wandered into the workshop, and then he photographed the whole workshop for us, and then sent us the photos. It was like this, just a beautiful kind of moment. And I think wherever Agua Sol y Sereno gathers, these beautiful spirits gather. And so these beautiful spirits here today are you. So each year, CENTRO hosts a large symposium in the second week of June that convenes our community across boundaries and barriers to address relevant issues in the field of Puerto Rican studies. We take advantage of the fact that we come up into this moment gearing up towards the 116th Street Festival and, importantly, the Puerto Rican Day Parade. So we try to move into the year knowing that we'll have a critical mass of people here. These events are essential. These like end of the semester conferences are essential because we gather with each other in person, and your presence here today communicates that this space is deeply needed. And I think we always end our events and begin our events thanking you for being here, because we are producing work in relation with and in response to what is being articulated to us as a need. But then when we actually have the event, when people are here, that's when we know, okay, this was what was needed, right? So every time people come here, we're like, okay, this is the right step, let's keep moving in this direction. So I just want to be really open about that. This year's symposium, A Sea of Islands, the U.S. Territories in Relation, is something that the CENTRO staff and I have been dreaming about for over a year. As the Center for Puerto Rican Studies, it is no question that our work centers Puerto Ricans, Puerto Rico, and those living in the archipelago and across the diaspora. However, we know that despite being surrounded by the sea, our experiences overlap with peoples of the U.S. Virgin Islands, Guam, the Northern Mariana Islands, American Samoa, and a litany of other places impacted by American imperialism. For decades, millions who call these places home or have yearned to return to these places have fostered connections across oceans and resisted colonial governance while preserving their sacred cultural traditions. In fact, this symposium draws its title from an essay written by Epeli Hauofa in 1994, Our Sea of Islands. In this essay, which I read in grad school, and which really transformed my life, thinking of archipelagic thinking from Oceania, thinking about it in the context of the Caribbean, foundational for me. And so again, like the crossing of this thinking is so important. So I just want to. In his essay, he asserts, if we look at the myths, quote, if we look at the myths, legends, and oral traditions, and the cosmologies of the peoples of Oceania, it becomes evident that they did not conceive of their world in such microscopic proportions. Their universe comprised not only land surfaces, but the surrounding ocean as far as they could traverse and exploit it. The underworld with its fire-controlling and earth-shaking denizens, and the heavens above with their hierarchies of powerful gods and named stars and constellations that people could count on to guide their way across the seas. Their world was anything but tiny. They thought big and recounted their deeds in epic proportions. There was a world of difference between viewing the Pacific and the Caribbean, and us as people, I would add, as islands in the far sea, and as a sea of islands. The first emphasizes dry surfaces in a vast ocean far from the centers of power. The second is a more holistic perspective, in which things are seen in the totality of their relationships, end quote. Today, our symposium aims to look beyond the legal definition of what it means to be a U.S. territory in a far sea, and see ourselves through the relationality Hauofa brings into light in this essay. We aim to ask pertinent questions like, what can justice and sovereignty look like for us? How can we build coalitions across geographies that have the power to change our material realities? Today and tomorrow, we have multiple panels from an inspiring cohort of scholars, researchers, authors, artists, filmmakers, and activists from across the globe. These individuals are not just reimagining what is possible for our communities, they are manifesting it. As you join us, I encourage you to use this opportunity to build community with other guests, engage in these questions actively. If there's one thing that CENTRO is proud to do is convening your abuela, your primos, your professors, your authors, political leaders, community activists, your friends, and others invested in this work to think big and recount their deeds in, quote, epic proportions. With that, I will hand it over to Dr. Carlos Vargas Ramos, the Director of Public Policy and Development at CENTRO, to kick off our first plenary this morning titled Territorialized People and the Law, Plenary Power, Decolonization, and Rights. Thank you so much and welcome.
Buenos días.
Buenos días.
Welcome. My name is Carlos Vargas Ramos. I am the Director for Public Policy, External and Media Relations and Development here at the Center for Puerto Rican Studies. Thank you for joining us for a Sea of Islands, Territories in Relation. We are pleased to start these 2 days of concurrent panel discussions with our first plenary panel, Territorialized Peoples and the Law, Plenary Power, Decolonization, and the Rights. This panel highlights the ways our territorial histories have been shaped by colonial institutions and will allow us to envision ways in which we can catalyze broader coalitions for legal reform and institutional transformation. And therefore, joining us in this panel, we have 6 wonderful panelists, beginning with, in the order in which they're going to be presenting, Professor Matthew Fletcher, who is the Harry Burns Hutchings Collegiate Professor of Law and Professor of American Culture at the University of Michigan. He sits as the Chief Justice of the Grand Traverse Band of Ottawa and Chippewa Indians, the Pokagon Band of Potawatomi Indians, and the Porch Band of Creek Indians, and serves as a judge for nearly 10 other tribal nations. Following his presentation, we have Professor Winona Single, who is Associate Professor of Law at Michigan State University College of Law and Director of the Indigenous Law and Policy Center. Her scholarship focuses on tribal sovereignty, indigenous rights, and federal Indian law. Her current book project examines the continuing effects of removal, land dispossession, boarding schools, and child welfare policies through both legal analysis and her family history in Michigan. We also have Dr. Alvin Padilla Babilonia, who is assistant professor at Villanova University School of Law. His scholarship focuses on the constitutional legacy of American colonialism and the relationship between law, race, and empire. Padilla Babilonia's scholarship has appeared or is forthcoming in the Minnesota Law Review, the Michigan Law Review, among others. In 2022, he was selected as a Bridging the Divide Fellow for the Decolonization Study Group funded by the Mellon Foundation and convened by us, the Center for Puerto Rican Studies. We also have Dr. Faye Kernan, who is Professor of Ethnic Studies and Associate Dean for Faculty and Staff Affairs in the College of Liberal Arts and Science at the University of Colorado, Denver. Her research specialty is in comparative ethnic studies and the study of U.S. imperialism. Her book, Legitimizing Empire, Filipino Americans and U.S. Puerto Rican Cultural Critique, examines how Filipino Americans and the U.S. Puerto Rican cultures challenge narratives of U.S. exceptionalism. We also have Dr. Carlisle Corbin, who is an international advisor on governance, former Minister of State for External Affairs of the U.S. Virgin Islands government. He was an independent expert on governance for the UN Development Program and governance advisors to various Caribbean and Pacific governments, as well as a lecturer in global affairs at the University of the Virgin Islands Global Leadership Institute. He is co-author of Giha Mona, a self-determination study for Guam, and author of The Evolution of French Colonialism from 2024. And we also are joined by Gretchen Sierra Solita, who has served as the first White House director for Puerto Rico and the Territorials and senior advisor from 2021 through 2025. Her work draws on her extensive federal experience, including posts with USAID, the General Accountability Office, the Office of Management and Budget, and the U.S. House of Representatives. Prior to her White House appointment, she led Polyvox 787, a public affairs and communications consultancy. So with that, I will say thank you again for joining us in this conversation. I would like to remind you to please silence your phones and be mindful of any side conversations. After each presentation, we will then assemble at the dais and we will engage in a moderated conversation, and we will also be posting and engaging questions that you may have, you the audience may have. There will be a QR code that you can find also in your program, and use that QR code to ask any question of the panelists that you may have. You also can write down the questions on the program itself. There are some pages in which you can use to write your questions. So to begin with, please join me in welcoming our first presenter at the stage, Professor Matthew Fletcher.
Bonjour, my name is Matthew Fletcher, and coming here from Michigan, citizen of the Anishinaabe tribes in Michigan, which is Ottawa, Potawatomi, and Chippewa, or Ojibwe. And I'm here to talk a little bit about some of the legal background. I'm going to give you a Constitutional Law 101. And I like the lawyers going first, so we can help you, we can explain where the edifice comes from, maybe show you where some of the cracks are, and then I guess you can spend the rest of the conference destroying the whole thing, which is totally the goal. So thank you for having me here, and it's great to have Myra. We saw her last year, and she said, "Hey, you're going to need to come to our conference," and we're delighted to be here. So here's my spiel. I didn't really do a PowerPoint. I have no idea what this stuff is anymore. So loosely speaking, I'm going to tell you a little bit about, like I said, constitutional law. I'm going to go way to the very end. And if you want a copy of this, I do have a couple of copies left over. So Plenary power. So let's start a little bit with the Constitution. In fact, before the Constitution, there's the Declaration of Independence, which is not really the law, but it's our 250th anniversary of the thing. And we need to point out what this is. This is the political theory of the United States. Nicely speaking, it is the social contract. It says, hey, we all agree that there is a government, has to exist, and we should probably be represented by it. But, and those of you who know a little bit about the Declaration know really what it is. And if you take contract law, basically first year of law school, what you will find in a contract is that really it's not about inclusion, it's about exclusion. And a social contract is, is still a contract. But fundamentally what it is about excluding people. So in the text of the Declaration, you see a reference to something called merciless Indian savages. That's me. And my wife, she's running out of the building. She doesn't want to hear it. Really, that's, in a lot of respects, it's all of us. And if you look at the Articles of Confederation that followed the Declaration and obviously the U.S. Constitution, the original text of this thing is about exclusion. The only people who could vote were white men of property, and fundamentally, those of us in the legal profession who wish very much to return to the notion of originalism or original public understanding of the Constitution, they only really want to know, or want us to know, and they want to be the law, what the original so-called founding fathers thought of the law. So, white men of property. And that says entirely a whole lot about fundamentally what the political theory is of the United States, and we've got to get past that. Otherwise, this whole thing is a suicide act. Anyway, on that fun note, let's talk about the portions of the Constitution that are relevant to our discussion here today. You've probably heard of the phrase the Property and Territory Clause. I'll mention that for a second. I'll also mention the Indian Commerce Clause and the Treaty Power and the Indians Not Taxed Clause. And all of those things are sort of in this weird constellation of a part of constitutional law, typically called the foreign affairs part of powers or the war powers. And Indian tribes were often at war with the United States, and that's sort of where we started. In the original version of the Department of War, that's where the Office of Indian Affairs originated in 1824. Later on, they moved us over to the Department of the Interior when they realized that Indian tribes were sitting on a bunch of resources and natural resources, so the Department of Interior is about giving away natural resources to those property white guys, and that's what they did. They gave all of our lands away, as well as most of the really valuable federal public assets, mostly just given away to political constituencies. And you might think that our current administration is doing really the same thing over and over again. This is not new. And it's an old story. But the Constitution puts into Congress, and to a lesser extent the executive branch, the war powers, the treaty power, the foreign affairs powers, all of that, the constellation of powers, is exclusively resides within those branches of government. Primarily Congress, but also, like I said, to some extent, the executive branch. So what does that mean for constitutional law? Fundamentally, it means that, according to the text, according to the Supreme Court, it means that the United States Supreme Court doesn't really have any say in war powers. I mean, in the moment when the president needs to react to a political situation that goes into a war, you don't have time for Congress to pass legislation. And if Congress does pass legislation, say a war powers resolution, you don't really want the Supreme Court to be second-guessing the political decisions of Congress or the on-the-ground, real-time, real-politic decisions of the president. So the Supreme Court, from the very beginning, has essentially treated war powers, foreign affairs, as the exclusive domain of Congress and the president. And the Supreme Court has just sat that out. And that's true in Indian affairs as well. So Congress has the power to regulate activities that occur on the property of the United States, that's national parks now, and also the territories of the United States, and that's what we're talking about, the Sea of Islands. The Indian Commerce Clause does basically the same thing vis-a-vis Indian tribes. Congress is what we call has plenary power in Indian affairs. Congress also has plenary power in the territorial law, I guess we'll call it. And that's where all this comes from, in the text of the Constitution. Why is it called plenary power? Because the Supreme Court called it that. The Constitution does not use that phrase. Plenary power in the dictionary means absolute. I don't think the Supreme Court would grant absolute power to Congress, but they have 5 votes and they can do anything they want. So that's where we are. We have plenary power because the Supreme Court has vacated the field, so when Congress does something in the territories and Indian affairs, The Supreme Court, at least until maybe the 1970s, said, no, we're going to touch it. It's totally up to Congress and to a lesser extent the executive branch. This is outside of our field. They technically call it a political question. That's non-justiciable. And that's important because when you give a branch of Congress, a branch of the government power, and then you have no limitations on that power to speak of that are meaningful, then you have plenary power. And that's where all that comes from. Now, if you want to talk a little bit more about why we have, what the possibilities are for moving forward, there are some cracks in the facade. And like I said, at least in Indian affairs since the 70s, the Supreme Court has said we might have gone too far in letting Congress just do whatever they want in Indian affairs, because Indian people are actually citizens of the United States, and they have other rights too, like the right to property. And if you take a vested property interest from somebody under the jurisdiction of the United States, you have to pay just compensation to them. You have to grant them due process and then pay just compensation. The reason that Indian tribes have treaty rights, by the way, fundamentally, is because if Congress terminated our treaties, and they could totally do this any day of the week they wanted to, they would have to pay us for all of that. Mm-hmm. So our tribes, for example, Winona and I, are treaty fishing tribes, treaty hunting and fishing tribes, fundamentally. And every year, there's a certain number of our treaty fishers that go out and make some money on fish. Not a whole lot. It was a lot better when the environment was good. Now it's crap. But there is money to be made every single year in treaty rights. And if Congress just said one day, all those treaty rights are gone, they'd have to pay us for that. So just imagine X amount of dollars for every year that tribes make, or Indian people make, on treaty rights. Multiply that out by until the end of the treaty, which is forever. That's an infinite amount of dollars. I like to say $1 trillion, let's say. It's a good number. Congress doesn't want to mess with that. The United States Department of Justice, which has recently passed the Department of Interior for the most evil department, in my point of view, also agrees. We don't want to mess with abrogating Indian treaty rights because then we'll have to pay them. We don't really like doing that. In the context of the territories, however, the United States does not acknowledge indigenous peoples as nations, that they do like Indian tribes, which is a deep, unfortunate thing. However, like I said, cracks in the facade. One of them is the United Nations Declaration on the Rights of Indigenous Peoples. Happy to answer a few questions about that. My wife is coming up next, knows as much about it as I do, if not more. The other thing is, in the last couple of years, the Supreme Court has said things about plenary power. They're like, well, we actually don't find this in the text of the Constitution either. At least a couple of the justices. Now, the ones that we like say things like maybe tribes should restart the treaty era with the federal government, although I don't really want to negotiate a treaty with a dude in D.C. right now. But also that much of what Congress does to directly regulate the activities of Indian tribes is probably unconstitutional. I kind of like that. The other people in the Supreme Court who don't think they see plenary power say things like, and we don't see plenary power, therefore it must mean tribal nations they don't have any sovereign power whatsoever. Indian people are basically just regular old American citizens, if they are citizens at all. And let's just get rid of the whole notion of tribal sovereignty. So we have a lot of potential disruption going on at the Supreme Court, as you can possibly know. And in our area, with plenary power in the territories and federal Indian law, that disruption is both a great deal of potential that may be really, really good, or it could just be the end of all things. So with that, I will turn over my time. I got 10 minutes. And look, there are good things coming up, so I'll say that. But that said, thank you very much for the time, and I'll turn it over to the next person.
Ani bonjour. Winona single indigenous waganak singo dawa in Donjaba, wabanang nakwejang and Dayan Nogum, and Mayim and Dodom. So my name is Winona Single, and I'm very, very honored to be here with all of you today. Thank you so much for hosting this event. And my talk today is on colonialism as governance of family, movement, and belonging. And so I just want to acknowledge that what Matthew was discussing in terms of constitutional law, it does give us a vocabulary for colonialism that focuses on tribal sovereignty and jurisdiction and plenary power. And there are huge important questions such as, what ultimate legislative authority does Congress have? and who controls territory. And these are very important and real questions, but I also say that they're incomplete ones, because what the doctrinal frame consistently misses is the level at which colonial governance impacts actual people's lives. And so I'm very interested in how colonial governance impacts the intimate infrastructure of our families and our family formation and continuity and stability, as well as our extended kinship networks and our capacity to remain attached to place and community across time and across generations. So my argument today is that if we want to understand how colonialism works and persists, not as a historical event or as a foundational legal doctrine, but as ongoing governance, we need to look at what it does to belonging. And we need to understand colonial administration as a technique for managing stable belonging and making it structurally difficult. So I want to offer a concept that I think does some helpful work in both the tribal and the territorial context, and I call it managed instability of belonging. Colonial systems govern not just by controlling territory, but by systematically destabilizing where people can live and with whom they can form families and how they can move and whether they can remain rooted in place and community over time. And that's not incidental to colonial rule, it's a feature. It's central to how colonial rule maintains itself. Fragmented populations organize with difficulty, and displaced communities struggle to transmit culture, accumulate political power, and sustain social bonds that enable resistance. And so the question I'm asking is not just what colonial law permits or prohibits, but it's what colonial governance produces in human lives and in our social structure. So the federal boarding school system in Indian law is perhaps the most explicit case in the history of U.S. policies toward Indian tribes. Kill the Indian and save the man, the famous motto of Colonel Richard Pratt, who is the person who created the system of Indian boarding schools. It's not just a cultural assimilation program. That phrase represented a systematic mechanism of fragmenting families and tearing families apart. Children were removed from their kinship networks and punished for speaking their languages and denied contact with their parents. The intergenerational effects of this on family formation patterns continues to this day. And of course, also in the mid-20th century, state foster and adoption systems removed indigenous children 8 to 10 times the rate of non-indigenous children, so that by 1978 it was observed that about 1 in 3 Native children in many communities were being removed from their homes and placed into foster care or adoptive homes. The practice was so extensive that by 1978 Congress did pass the Indian Child Welfare Act in an attempt to counter it. And now also in the recent Supreme Court case of Brackeen versus Holland, the federal courts are being asked to reframe family protection as an impermissible racial preference. And so while that issue wasn't directly addressed in the Supreme Court decision in Brackeen, we still know that there are many litigants that are seeking to undo the Indian Child Welfare Act's protections using equal protection as a wedge and a tool to dismantle this legal structure that is intended to recognize indigenous family integrity and protect it, both as a political and a cultural matter, not just as a private family matter. And so I want to acknowledge that in Puerto Rico, the mechanism looks different, but the structural outcome is the same. So PROMESA, for example, and the Fiscal Control Board of PROMESA has mandated austerity measures that make family life economically extremely difficult on the island. Between 2017 and 2019, we know that 283 schools were closed, displacing 42,000 students. And also healthcare has suffered a collapse that has forced families with medical needs to migrate. We also know that research after Hurricane Maria shows that 31% of those who left reported leaving family members behind. And so what emerges is a pattern that scholars have called transnational family fragmentation. Working age adults migrating for employment opportunities while elderly parents remain, families shuttling between island and mainland, family formation becoming genuinely precarious in the face of a question that should not be existential. Where can we build a stable life together? Colonial powers need not pass explicit family separation statutes when economic structures and service cuts accomplish the same result. Let me turn to mobility, because this is where the colonial logic gets very revealing. Colonial systems simultaneously restrict certain movement. And so we know, of course, also we've had a history of forced removal of Native people, reservations established, restrictions on trust land, but they also compel other movement through things like the history of relocation in federal Indian law in the 1950s, and the production of economic conditions that make staying impossible. The BIA's urban relocation program of the 1950s and 60s actively recruited reservation residents to cities, presented as opportunity, but functioning as population management. It weakened tribal communities as a result and disrupted tribal kinship networks, producing a dispersal across geography that made collective governance much more difficult. And one of the parallels in Puerto Rico is Puerto Ricans' per capita military service rate, which is among the highest in the nation in a context of structural unemployment, where military service can be viewed as an economic necessity rather than civic choice, extracting young people from communities that are already under demographic pressure. After Hurricane Maria, between 130,000 and 140,000 people left Puerto Rico. Federal disaster response was starkly inadequate. If we compare FEMA assistance, we see that FEMA assistance averaged roughly $2,500 per household in Puerto Rico. If you compare that to Hurricane Harvey in Texas, families received $7,000 per household. Infrastructure afterward had collapsed, schools closed, and healthcare became inaccessible. The migration that followed is consistently described in official discourse as voluntary. But voluntary is doing enormous work in that sentence. When staying requires enduring conditions that have been made unlivable through a combination of deliberate policy, fiscal control, and inadequate federal response, departure is no longer a free choice. It's a managed displacement by other means. The same logic applies to the, quote, voluntary economic migration produced by decades of austerity and colonial economic structure. The concept of voluntarism obscures the structural coercion underneath it. The demographic data also gives this argument some more background. Puerto Rico has lost 700,000 working age adults in the last 15 years. The proportion of adults over 65 has grown from 13% in 2010 to over 21% by 2021. A pace of aging that researchers have called unconventional, and it has no documented parallel. Kinship models now show that a 65-year-old woman in Puerto Rico can expect roughly 69% of her close female kin to be living in the continental United States. Adult children, the primary caregiver reference in Puerto Rican elder care, are structurally absent. And what this means is that the social infrastructure of caregiving, of mutual support and intergenerational attachment has been physically distributed across a transnational geography by the accumulated weight of colonial economic management. This managed instability of belonging is then quantifiable. Also, the political consequences follow from this dispersal. Puerto Rico's diaspora now numbers about 2.8 million people in the continental United States, compared to approximately 3.2 million on the island. Those who left cannot vote in Puerto Rico's status referenda. Those who remain face diminished demographic and economic power. A population that has been structurally dispersed across geography struggles to achieve consensus, sustained political pressure, and exercise the collective self-determination that decolonization requires. In Indian country, a parallel dynamic plays out through the disconnection of urban Indians from reservation governance, enrollment disputes, and the jurisdictional instability that continues to plague Indian country, with ongoing state challenges contesting tribal jurisdiction. Unstable jurisdiction produces unstable belonging, and that's not a coincidence, it's a feature. So let me say plainly what I think this framework does, work that sovereignty-centered analysis cannot. First, this reveals structural continuity. PROMESA's austerity mandates and the federal boarding school system are temporally and mechanically distant. However, they are functionally comparable as techniques that produce populations unable to maintain stable attachment to place and community. Second, I think this is important because we need to bridge our silos. Federal Indian law and territorial law are typically treated as separate fields, but examining governance through family and mobility reveals structural parallels that suggest shared colonial logics and potentially grounds for coalition. And third, this reframes what decolonization requires. If colonialism operates through family fragmentation and managed displacement, then decolonization cannot stop at constitutional status or sovereignty doctrine. It must also address the economic structures, the healthcare systems, the educational institutions, and jurisdictional conditions that make family integrity and rootedness possible. So, constitutional doctrine asks, who has sovereignty and where does jurisdiction lie? These are necessary and important questions, but they're not enough. We also need to ask, who can form families and where? And who must move and who can stay? And under what conditions can communities remain intact across generations? Who bears the costs when they cannot? These questions reveal colonialism not as a historical event with a fixed endpoint, but as an ongoing governance of the intimate infrastructure of belonging, one that adapts, operating through administration, fiscal control, and economic structure, rather than explicit conquest, and targeting the social bonds that enable resistance as surely as any territorial claim. So 80 years after the UN Charter, 125 years after US territorial acquisition, decolonization remains incomplete, in part because we have not yet fully seen what it is we're trying to undo. I hope this framework helps us see it more clearly. Miigwech.
Buenos dias. I'm really happy and honored to be here today with all of you. I'll begin with a tension, which is the tension between U.S. constitutionalism and colonialism. I started approaching this question from the perspective of Puerto Rico, right? So Puerto Rican residents are citizens of the United States with constitutional rights. At the same time, Congress has plenary power over Puerto Rico, even though Puerto Rico has no meaningful representation in Congress. One way to resolve or ameliorate this tension between constitutionalism and colonialism is to extend to Puerto Rico full constitutional rights, or to limit some of these congressional plenary powers and have Congress only have enumerated powers over Puerto Rico. In my scholarship, I tried to adopt a different approach. What I tried to focus on is what the experiences of racism and colonialism, which includes racial minorities living in the states and cities, Indian tribes and territories, what do these experiences reveal about the limits of U.S. constitutionalism and how to transcend those limits in the present moment? In this paper that I'm going to be talking about today, I focus on the issues of land rights and housing, and the topic is race-conscious remedies addressing housing and land inequities for racial minorities, Indian tribes, and U.S. territories. I'm going to try to think about these things together. So I'll begin briefly with the constitutional law on this topic, and I'll begin with thinking about race. I'm going to be discussing the constitutional law on race, Indian tribes, and territories. So if a state or a city wants to enact a race-conscious remedy to address the inequities in access to housing, the Supreme Court and federal courts consider that to be a racial classification. So if there's a city that wants to build public housing in predominantly white neighborhoods, because that includes a racial classification that's usually going to be struck down and declared to be unconstitutional. That is the constitutional law with regards to race on this topic. Now, with regards to Indian tribes, in regards to Native nations, federal laws that distribute tribal lands or provide tribal lands to Indians and Indian tribes are not subjected to this heightened level of review, because these types of classifications are not considered to be racial, but are considered to be a political classification. Finally, with regards to the context of territories, and here most of the cases come from the Pacific territories, American Samoa, Northern Mariana Islands, and Guam, federal courts have adopted a different type of solution, which is to say that these race-conscious remedies, trying to, again, address these inequities in access to land, are actually not struck down. They're actually, courts apply a more differential analysis, and these types of policies are usually upheld. And part of it, the reason of why the courts have upheld this land alienation restriction is because territories are considered to be kind of like different in this way. So again, to provide a quick summary with regards to race, the framework that has applied is mainly an anti-discrimination framework under which any type of racial classification is discriminatory, even one that is trying to remedying past inequities. While in the context of Native nations and the territories, the courts have adopted what I describe as a more self-government type of framework. Now, today there are present challenges to these race-conscious remedies in all these different contexts, and Matthew and we're going to talk a little bit about this as well. But basically, there's two challenges today for the constitutionality of these race-conscious remedies. One challenge comes from the Supreme Court's approach to equality, this colorblind approach to equality, right? And there's a fear that this colorblindness might be being extended to other fields, right? Like Native nations and the territories. And one example of that is how during the first Trump administration, the Chamorro Land Trust Act was challenged as actually unconstitutional because it has race-based classification. That's the first challenge today. The second challenge today comes from some of the Supreme Court justices have critiqued the idea of plenary power over Indian tribes and the territory. And what has happened is that the idea of plenary powers, what it has been repurposed to justify some of these Indian preference and also to upheld the constitutionality of this land alienation restriction. So again, there's this difference in terms of how U.S. constitutional law treats race-conscious remedies for housing and land rights with regards to each group. But there's a present challenge today that might collapse all these distinctions, and in the future, maybe all of these race-conscious remedies might be unconstitutional. So my approach to this question is, rather than focusing on core center solutions or trying to influence federal legislation, my approach is a constitutional politics of housing and land rights that resists the idea of colorblind law and try to explore how grassroots mobilizations and local democratic politics can secure housing and land rights for all marginalized peoples. So I'm trying to think, rather than a constitutional law, I'm trying to think of a constitutional politics from below, where the people most affected by these types of issues can actually resist the idea that there should be a colorblind law applying to this thing, and try to think about it from the perspective of anti-colonial solidarities. So I'll say something briefly about each of these things that I think of my as constitutive parts of my approach of constitutional politics of land rights and housing. So the first one is this idea of anti-colonial solidarities, and here, basically, what I want to say is that it's common, and for very valid reasons, I have to say, but it's very common for if Indian tribes want to preserve the constitutionality of Indian preferences, to kind of like emphasize the things within U.S. constitutional law that give them an opening for the constitutionality of those types of Indian preferences, right? But those types of opening, like to say that it's a political classification, might actually not do anything to preserve the constitutionality of race-conscious remedies for Black Americans living in a city, right? So in thinking about it from a perspective of anti-colonial solidarities, what I would like to see is movement kind of like resist this zero-sum game of U.S. constitutional law through these two ideas of anti-colonialism and racial solidarity. So I think of anti-colonialism as a critique of racial and colonial domination that also has a transformative agenda, right? And what I'm trying to argue is that this type of anti-colonial framework should be more important when we discuss these types of issues. I also think it from the perspective of racial solidarity, right? And with anti-colonial solidarity, I'm trying to bridge those two concepts. And I see race as a source of community that connects individual experiences with societal structures, right? So when I say that we should resist colorblind law, what I'm trying to argue in a way is that through anti-colonial solidarity, people affected by these types of decisions should rely on their distinct identities as their distinct racial identities to build community with other people who are similarly affected. And this, again, I think of it as a joint movement of racial minorities in the states, territories, and Indian tribes. Second idea here, very quickly, is this idea of grassroots movements, right? So rather than, again, more top-down approaches focusing on core-centered solutions of federal laws, I do think that this type of response, this type of resistance to colorblind law needs to come more from grassroots movements and coalition building. And more importantly, maybe these movements, they don't want to talk they don't want to use a constitutional vocabulary or a constitutional register. Maybe they don't want to discuss these terms based on what the Equal Protection Clause of the 14th Amendment means. Maybe what they want to do is actually talk about it from the perspective of reparations or from the perspective of international human rights, right? And this should be something important that these grassroots movements, the way that they make claims against their own governments. Finally, with regards to democratic politics, and I think this is a key part of my argument, is that resistance to colorblind law in order to have land and housing for all marginalized peoples should actually focus locally in cities, tribal nations, and the territories. This is because housing and land policies are usually made at a local level, but more importantly, these communities have greater political power locally, right? So think about large urban centers where racial minorities constitute a really significant part of the population, right? So rather than thinking of these racial minorities kind of like passive recipients of judicial review, we should think about what can they do politically, right, to address these types of issues. I also have kind of like a series of policy proposals for thinking about how cities in the tribes territories can address some of these issues, right? And just to end on this, the argument would be like, for example, let's say some cities start adopting race-conscious down payment assistance. It could be that the Supreme Court or federal courts decide that those types of racial classifications are unconstitutional. But my main argument here is that I think through enacting this type of policies, communities can build political power together. They can build coalition with other anti-colonial movements, and through that, there can be a more politicization of these issues in a way that kind of like transcends the current constitutional limits and the current constitutional law vocabulary that I think does not really address these types of issues. Thank you very much for your time.
So first I want to start off by saying I'm not a legal scholar. I'm an ethnic studies professor, and I came to be thinking about territorial citizenship because I was looking at immigration files in the archives and came to this realization about what the limits of territorial citizenship and kind of the benefits of territorial citizenship. So let me begin by kind of talking about what I mean by territorial citizenship. So after the end of the Spanish-American War, when sovereignty of the Philippines, Puerto Rico, and Guam were transferred from Spain to the U.S., the United States was, they wanted sovereignty over the islands, but they were trying to figure out what do we do with these, with the people on these islands, right? I think they weren't going to displace the indigenous populations like they did in the mainland U.S., and they were thinking about the purposes of these new colonies, and how they would be using these in ways other than settling them. So, I think about how they thought about incorporating these new peoples without trying to give them all of the rights and benefits of U.S. citizenship. So what they came upon was creating these new types of citizenship. So for Puerto Rico and the Philippines, they actually created Philippine citizenship and Puerto Rican citizenship. So the people on these islands, if they qualified, were citizens of the islands, but they only had U.S. national status, which meant they didn't have the full benefits of U.S. citizenship. And the way that they determined who was able to get citizenship was really if you were a Spanish citizenship, or if you were a citizen of Spain and a resident of the Philippines and Puerto Rico, when the treaty was ratified in 1899, then you would become a U.S. territorial citizen. You would become a Philippine or Puerto Rican citizen, and you would have U.S. national status. What I have here on this slide is a picture of a passport from someone who had Philippine citizenship. So when a Philippine citizen would travel to the U.S., this is the certificate that they would show saying that they had U.S. national status. One of the benefits of U.S. national status was that you could travel anywhere within the U.S. empire. And so when I try to think about what was the point of U.S. territorial citizenship, I think that there were a few, the creation of U.S. territorial citizenship for the U.S. Demonstrated this, the idea of benevolent assimilation that the U.S. was trying to say, we have these colonies, but we're a different type of empire because we are going to benevolently assimilate our new territories. So these new citizenship was a way of demonstrating that they were benevolent, a new benevolent empire, imperial power. It also allowed for them to exercise sovereignty, right? That these territories then became part of the U.S., but also these peoples, right? Because they had this new political status. And lastly, when I mean exclude the new territories, I meant that what I mean is that this allowed them to then have U.S. exclusion laws. So the immigration exclusion laws for Chinese, the Chinese Exclusion Act, the other ways that Asian folks from Asian countries were excluded from coming to the U.S. These exclusion laws were then able to be enacted on the new U.S. territories. So, though Philippine and Puerto Rican citizenship were similar, they also have slightly different timelines, and then these timelines become different as the U.S. Determine kind of different political paths for the Philippines and Puerto Rico. So in the Philippines and in Puerto Rico, the 1902 Philippine Organic Act in the Philippines and the 1900 Four-Acre Act in Puerto Rico, they both do similar things in that they make the Philippines and Puerto Rico unorganized territories and establish a civil government as opposed to the military government that was in place prior to that in the Philippines and Puerto Rico. And then they create these citizenships, Philippine citizenship and Puerto Rican citizenship. And then in 1917, we kind of see a divergence between the two. It should be the 1916 Jones Act for Philippine citizenship. I have the date wrong there. But you have the 1916 Jones Act in the Philippines that actually for the first time talked about how the Philippines would eventually become independent. And so the 1916 Jones Act keeps Philippine citizenship for the Philippines, but talks about this kind of future independent state. Whereas the 1917 Jones-Shafroth Act in Puerto Rico gives U.S. citizenship to Puerto Ricans, so kind of implying that there's going to be this longer political relationship with Puerto Rico. Again, you see that divergence there. One of the effects of the 1917 Jones-Shafroth Act in giving U.S. citizenship to Puerto Ricans was that they were then able to serve in World War I, be recruited into World War I. Now, I want to emphasize that the Puerto Ricans getting citizenship in 1917, that this was a statutory citizenship. It was granted by Congress and not the Constitution. And this creates some issues moving forward. In 1934, in the Philippines, there's the Tidings-McDuffie Act. It's also known as the Philippines Independence Act. What happens here is that the Philippines officially becomes a U.S. Commonwealth, but that in getting a certain amount of political independence, U.S. national status is taken away from Filipinos in 1934. So after 1934, Filipinos are no longer able to travel anywhere within the U.S. empire, and those Asian exclusion laws then apply to Filipinos. The year after that, there's the 1935 Philippines Repatriation Act, where Filipinos are incentivized to go back to the Philippines. So really, it was a way to remove Filipinos from the United States. And then the 1934 Tidings-McDuffie Act also specified that within 10 years, the Philippines would become independent. And so roughly on that timeline, the Philippines, after World War II, does become independent. For Puerto Ricans in 1940, the Nationality Act extended birthright citizenship to all those born in Puerto Rico, and then also retroactively applied that to the folks who were able to get Puerto Rican citizenship. So again, implying that kind of longer relationship between the U.S. and Puerto Rico. So I think, as I said, the reason why I came to this idea or came to look into U.S. territorial citizenship was really because I think that the conflicts or there are some interesting issues that come when one is trying to travel as a territorial citizen, right? Because on the one hand, you have these the benefits of traveling as a territorial citizen, but then you're coming to the U.S. and you're not a U.S. citizen. So there are certain things that happen when you get to the border. And so there were ways that, especially right in the beginning, there were ways in which folks who were traveling as territorial citizens really had to assert their territorial citizenship rights. And I'm just going to kind of briefly give some examples. The first example of how territorial citizens were really made to assert their territorial citizenship rights, I wanted to talk about the case of Isabel Gonzalez, who traveled from Puerto Rico to Ellis Island, in the early 1900s, and she was stopped at the border because if you were likely to become a public charge, then you were excluded from coming into the United States, and it was determined that she was likely to become a public charge. But then she sued, arguing, I'm not an alien. I come from Puerto Rico, and that makes me an American. And she asserted her territorial citizenship status. And this went all the way to the Supreme Court, and they found in her favor. So that kind of set a precedent for those migration rights for territorial citizenship. Now, another thing is that I want to talk about is these conflicting political statuses. So I was talking about the Asian exclusion laws. So if you were a Chinese Filipino, you were both a U.S. national, but since you were ethnically Chinese, you were subject to the Chinese exclusion law. You were an alien who was ineligible for citizenship, and so you could be excluded from coming to the U.S. So you had these Chinese Filipinos, U.S. nationals, who would come to the United States. They would get stopped, at Angel Island, and they would show their passports, like the one that I on the prior slide. This really caused a lot of confusion for folks working in immigration, because they're like, well, you look Chinese, and we should be able to exclude you. I could talk longer, but there was a way in which this evolved over time, because at first, when they would show their certificates, the immigration officers really had a lot of leeway trying to figure out, well, am I going to let you in because you look more Chinese, or am I going to exclude you, right? Because you're so there was a lot of leeway there that then, through different court challenges, becomes more and more refined until we lead up to the 1934 Tidings-McDuffie Act. So just the way that those conflicting political statuses, alien and eligible for citizenship and U.S. national status, kind of come together at the border. And then lastly, I want to talk about the changing political statuses. So for Filipinos, they're in the 1934, when the 1934 Tidings-McDuffie Act was enacted, there were actually Filipinos who were en route from Manila to San Francisco. And so when they left Manila, they were U.S. nationals, and when they got to the United States, they were aliens who were ineligible and for citizenship, and so they were able to be excluded. And so they were excluded, but then they were able to try to challenge that in the court. So they were let in on bail, and then eventually most of those mainly male laborers were found that they could be deported, and so they were subject to deportation about a year later. So I just wanted to talk about how U.S. territorial citizenship gave limited rights and really was really precarious. I mean, I was just thinking about what some of the other panels have already said, especially you, Winona, with talking about the types of families that can be created. Like there were ways in which, the shape of Chinese Filipino families who were trying to migrate were really impacted by these conflicting political statuses. And so when I've given this talk before, I've thought about how folks will often talk about full citizenship rights as a way of kind of leveling the playing field, or being able to really be equal. But then the way in which I've seen these kind of immigration cases, or even the territorial citizens, when they're trying to come to the U.S., their argument is always, I'm not going to be a public charge, or I'm a good worker, and so I should have these rights to U.S. citizenship. And for me, it really reminds me of, citizenship rights are very precarious, and that we should be thinking about organizing around something else. Like, what could decolonialism look like if we're not just focusing on becoming more incorporated into the U.S. through citizenship rights? Because, again, I think that there are ways in which citizenship rights are, even if you have those full citizenship rights, right, you're not recognized. If you're not seen as belonging, you're not necessarily given those rights. Thank you.
I would like to focus on the issue of decolonization aspect of our discussion. I begin with the U.S. Constitution. If we look at Article 6, it says that all treaties made or shall be made under the authority of the United States shall also be the supreme part of the land, the supreme law of the land. So treaties are, in fact, U.S. law. As a result, one of those particular treaties is the United Nations Charter. And there's a particular role of the United Nations Charter in all of the territories, all 5 U.S. territories as well. There's the French, the British, the Dutch, and in the Pacific, the New Zealand territories. Now we know the U.S. territories being American Samoa, Guam in the Pacific, U.S. Virgin Islands, Puerto Rico, Northern Marianas also in the Pacific. And we have, particularly with respect to the Charter of the United Nations, there are three main articles that deal with the self-determination of territories. Article 1 and 55. Article 73B in particular is critical because it talks about the question of the obligation, the legal obligation of the United States and other administering powers to bring the territories to the full measure of self-government. There are other international instruments as well that relate to this question. The International Covenants on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights. These are the human rights mechanism, human rights conventions that deal specifically with this issue. There are others that have been mentioned. The International Covenant Convention on the Elimination of All Forms of Racial Discrimination, and what was also mentioned earlier, the UN Declaration on the Rights of Indigenous Peoples. Particular resolutions of the UN give substance to the Charter, and particularly 1514, which is the Decolonization Declaration, which indicates that all peoples have the right to self-determination. Resolution 1541, which is a companion resolution, effectively sets forth the self-government principles. Both of these are 1960, and these principles are providing the minimum standards for self-determination and for full political rights, and what is referred to absolute political equality, independence, free association, and integration. The two, free association and independence, are merging a bit under the broader realm of sovereignty. As a result, in 1946, all of the U.S. territories were placed on the list, including territories that we know are remaining on the list. The only one that Panama Canal has come off the list, Hawaii has come off, and Alaska. But as a result, over 80 territories have achieved the full measure of self-government since the Charter was adopted. And what we have today are 3, American Samoa, Guam, U.S. Virgin Islands. Puerto Rico is also partially addressed by the United Nations. In fact, next week there will be upwards of 70-some-odd representatives of NGOs, civil society, of course, political parties, individuals who will be speaking on the question of the decolonization of Puerto Rico at the United Nations Decolonization Committee. So we have a number of dependency models of those 5. I'll just go briefly. Puerto Rico has been addressed. I think that I won't go too far with that. But what has happened, of course, in a similar fashion, as the previous speaker mentioned, that there was, in fact, military dependency governance that began at the transfer with respect to Puerto Rico, Philippines, and also with respect to Guam. Interestingly, the transfer to civilian dependency governance for Puerto Rico only took about a year, whereas the other territories, Guam, it went all the way to 1950. We had also situations whereby citizenship was provided at different levels, as was referred to. We look at the number of referenda that were held in Puerto Rico, and we find that there have been a number of opportunities for the determinations to be made, but depending on how one interprets the results of those referenda, it's either inconclusive, or some would say that statehood was in fact the winner in those referenda, although so far the congressional follow-up on this has not been fully completed. With respect to U.S. Virgin Islands, we came out under Denmark, and that was an interesting development. We also went through a military dependency governance period upon the acquisition by the United States of the territory. It took 10 years for limited U.S. citizenship. We had the Organic Act, the first Organic Act 1936, revised in 1954, Our first elected governor was 1971, and 1972 we had the non-voting delegate to Congress. We had one political status referendum. That was, in fact, in 1993. It was originally scheduled for 1989, except for the intervention of something called Hurricane Hugo, which provided us with the idea that we had to postpone it, and we did. And of course, the results were inconclusive. Interestingly, that was our first and only referendum on political status options. We had 7 options, which were far too numerous, and in retrospect, was the reason for the demise of the referendum. We've had 6 constitutional conventions in the interim period. Currently, there's one. The 6th convention is underway. One of the representatives of the convention is actually here this morning. Still morning. And luckily, she'll take solace in the experiences of the other 5, particularly the last one. There was the referendum, again, was originally scheduled for in terms of political status, 1989. What happened was, in fact, that we reverted to dealing with the Constitution, so that deals with how we structure ourselves internally, as opposed to what our relationship with the United States and the world would be. American Samoa, moving quickly, they're unincorporated and unorganized. And I think they also have, the previous speaker referred to the issue of U.S. national status, and they are, in fact, U.S. nationals. Now, they went through a period of ceding power to the United States military, and they went forward through a number of developments where their national status was recently subject of discussion in regards to a court case whereby the birthright citizenship question is, in fact, that's something that is ongoing. However, the governments of American Samoa, both political parties, as well as the delegate to Congress, the governor, have all indicated their reticence to accepting U.S. citizenship because of issues related to control of their land. Their concern is that their land rights could be affected by that. Now, this is something which also it resulted in their declining to move toward a Commonwealth status, similar to what Guam was seeking at a time, because of the concerns of land ownership. And one of the issues in Guam, of course, is land ownership. They also have opposed some amendments in terms of U.S. political power, so it's a very interesting balance in the context of American Samoa. Guam, finally, the unincorporated organization, they're unincorporated, very similar to the U.S. Virgin Islands. It's a structure. 15 members of the legislature, although the U.S. Virgin Islands is multi-island governance, whereas Guam is one island. There's a big difference in that respect when you're 45 miles apart. There was a transfer from Guam similar to the case of other territories under Spain, which was transferred as the spoils of the Spanish-American War. Their military dependency governance period lasted up to 1950. Right now, the U.S. military controls 33% of the land, and it really has implications for the environment, their ancestral lands, the preservation of culture, artifacts. One of the interesting elements of this is the impact on housing, which has increased the housing costs and also has increased the cost of living, and this is a major consideration. Now, there have been UN resolutions for decades with respect to ending military activities, not only in Guam, but also other territories as well. Much of my work is with French Polynesia, and that has a lot to do with the nuclear testing question. The issue of whether or not resolutions are binding, whether or not resolutions are ignored. In the case of Guam, they have been ignored. In the case of French Polynesia, the French seem to have also ignored them. Now, in the case of Guam, you have also the vote. They had one territorial constitution. That was 1979, and it was defeated by 81.7%. And part of the rationale was that the constitution of a territory cannot address the question of their political evolution. In other words, a territory with a constitution is the same as pretty much a territory without a constitution, because, in fact, the territorial clause still applies. Now they created, Guam created a Commission on Self-Determination in 1980. They developed a Commonwealth proposal, and ultimately it was adopted by the people in the territory. It was submitted to Congress, and Congress effectively stalled and did not go forward with adopting it. And also the U.S. Justice Department was not in favor of it because it was effectively seen as too autonomous. And it was patterned not on Puerto Rico's model, but rather on the model of the Northern Mariana Islands. I have 1 minute. Effectively, we go to the Northern Marianas, and they came out of a different approach. They came out of the trust territory of the Pacific Islands, and they are one, and effectively, ultimately resulted in a Commonwealth arrangement, which is in fact very, very autonomous. The question of decolonization or colonial reform, I'll end with that. We have a territorial constitution before political status. We have pursuit of U.S. presidential voting rights. We have a number of other, we have a territorial delegate, House vote, delegate status in the U.S. Senate, rejection of the insular cases. These are all initiatives which have been undertaken by our leaders. And in fact, these are effectively arrangements that are initiatives that have not been fully vetted with people, and these implications of these things have to be carefully examined. In the various moments of, again, we have under the Decolonization Declaration and its companion resolution, there are 3 options: independence, free association, and integration. They have minimum standards that apply to those, so that we even though the models may be different, there are standards that apply. And I think that will be my concluding observation with respect to that. Certainly, we are incomplete. Our territories are incomplete. And we exist in a fundamental imbalance of power. And of course, the status that we have was never meant to be permanent. It was always meant to be transitional to a permanent status. And I think we've kind of sunk into a comfort zone, which is not in our interest at this moment. Thank you very much.
Thank you, CENTRO, for having me back here. It's really nice to see a lot of old colleagues and friends, so I'm a big fan of CENTRO, so thanks for the opportunity. So, my name is Gretchen Sierra-Zarita, and I'm going to take a different tack. So my fellow panelists here today, they have discussed in different ways how the U.S. legal framework incorporates colonized people just enough to legitimize federal authority, but not enough to grant political powers to challenge or dismantle the governing structures. I would like to take a different tack and focus on the executive branch and make a parallel argument of how the manner in which federal policies are designed and programs are designed and implemented enable the territories to not to survive, but not to thrive, perpetuating the dependency of the territories on federal resources. And to kind of lay this out, I'd like to start by giving a little history of the administrations of the territories, which not everybody might be familiar with. So the early 20th century, the territories were under the War Department, Department of the War. In 1934, FDR, President Roosevelt, created the Division of Territories and Island Possessions within the Department of Interior. At the time, they had Alaska, Hawaii, the Philippines, and also Guam, Puerto Rico, and U.S. Virgin Islands were under this jurisdiction. In 1953, Puerto Rico broke out. That was when it became a Commonwealth. That's when it was taken off the list of non-self-governing countries in the United Nations. And essentially, at that point, Puerto Rico became the territory without a federal home base. Kind of the same way the states are, except that it's not a state and it did not have the benefits of the states. The other 4 territories remain and still are today in the Department of Interior and under the Office of Insular Affairs, which administers like technical assistance programs for the American Samoa, Guam, Commonwealth of Northern Marianas, and U.S. Virgin Islands, and also manages the compact of free association funding for Marshall Islands, Palau, and Micronesia. There is absolutely no interagency coordinating body at the federal level, and there's no territorial advisors embedded in the federal departments and agencies. Whatever decisions are taken is with the knowledge of whatever institutional knowledge there is in departments and agencies, but there's not somebody actually looking out at the distinct differences of the territories. The consequence of this is that we have the federal government frequently formulates policies and programs that disregards the legal, political, socioeconomic, workforce, and geographic realities of the territories, which are very different from the states. The neglect is not always statutory. I mean, it's not there's a law that makes them to do this. The neglect is often institutional indifference. It might be benign. It's not malicious. It might be benign, but it's still indifference. A lack of political will to confront the form of discrimination, and this is something that gets lost, that is separate and distinct from race or ethnicity-based discrimination. People assume that being of color and being from territory is the same thing. It is not. It is a very distinct form of discrimination, and that's something that is often lost at the federal level, if not completely. And finally, there is denial of the fact that these territories are there, as evidenced by the resistance to use the word colony. People are really get defensive if you use the word colony inside the federal government. And when you're trying to move things along and work things towards a point of progress and just make progress, you refrain from using that word because you want the people you're working with not to feel threatened by you. And so there's this kind of forced denial of who we are. To me, it reminds me of when we used to call people Negroes because it felt nicer than whatever the alternative was, and that's just there. Now, on a personal note, this ended in 2021. At that point, the whole way we're kind of organized, it was the first time that we had somebody in the White House looking after the territories, and that's when the position of White House Director of Puerto Rican Territories was created. And basically, that position was kind of a spoken wheel situation, devised for advising, coordinating, and liaising both with external and internal constituencies within and outside the federal government. When I started working at the White House, and throughout the 4 years, people, often come and ask me, well, so what is it like to work at the White House? And the one thing I would tell every time was the sense of sitting in a room at a meeting, at a regular meeting, it could be about anything, the topic was irrelevant, and thinking, there has not been a territorial person here in 122 years. And there had not, because that was just not part of the way of the thinking. And I want to underline that word territorial, because I think we need to start calling ourselves territorials and not Puerto Ricans or Romanians or Virgin Islanders, because we are all territorial, and it's the thing that unites us. Now, going into the Biden years, that changed completely. My position was created. Before I go into Biden years, some of you are going to say, what about the Puerto Rico Task Force that we all hear about? Yes, we had Puerto Rico Task Force. We had them under Clinton. That was the first one. Bush 2, Obama, obviously not Trump. They dealt with the issue of the political status. The only different one was the Obama Puerto Rico Task Force, which produced, in addition, a report on economic development, which is still worthwhile reading because it contained a lot of good ideas, many of which have not been implemented. And it was very thorough. Strangely, it was done between Democratic staff and Marco Rubio staff, which I'm amused, but whatever. Anyway, so we get to the Biden years, and they decide we are not going to broach the status. It's not that they're indifferent to it, but they just believe we're going to leave this to Congress because in any event, we cannot move without Congress. And in fact, when the Status Act was passed in the House, the Nidia Velazquez bill, the administration at the time, just for clarity's sake, did issue a statement of administration policy that said it supported that particular bill in response to congressional action. But moving on, so under President Biden, we had something called the Puerto Rico White House Working Group, which was under the leadership of the Domestic Policy Council, the National Economic Council, and the White House Office of Intergovernmental Affairs. And it was supported by an intra-agency committee called the Interagency Policy Committee. It was composed of members of all the departments and agencies, and a focus on economic growth and recovery, workforce and educational development, and transparency in governance. Now, just so for educational purposes, in the Domestic Policy Council and in the National Security Council, you have these IPCs, that's what they're called, interagency policy committees, that brings people from all departments to study an issue, a problem that they want to solve. The only IPC that was place-based was the Puerto Rico IPC. And in that, it was really an issue. It was centered around a geographic location, not around an issue. The point of the IPC was to coordinate, implement, and maximize whatever existing programs were to make it better. And there was a realization that they were trying to swallow up the whole ocean. So the following year, it was kind of reduced down to economic development type of issues. And then the president appointed at the time an economic recovery coordinator, which is Don Grace, the Deputy Secretary of the Department of Commerce. And he led this project in conjunction with Puerto Rican government and the governor to execute on 50-something deliverables. Most of it were done. And they all had to do with some type of economic development issue. Because of capacity issues, a lot of them had to do with building up the capacity in Puerto Rico to implement something later on. So a lot of it was at very much ground level in a place like Puerto Rico that has a lot of people and more talent to draw on. In addition to those kind of issues, the IPC also supported the grid modernization that the Department of Energy was leading under Secretary Granholm. It supported recovery and reconstruction under FEMA, and we did do it. It just did not work out. A lot of work on the construction workforce in Puerto Rico, which continues to be a problem. This is one of many models, so I don't want you to think this is the only thing that you could do, but it's one that could be applied in some way or form to all the territories, not just Puerto Rico. And I wanted to be clear, this is unexplored territory. I mean, I look a lot to the tribes, who I consider as allies and people that have gone down this path and are much farther ahead than we are in terms of representation within the federal government, although not as far ahead as they deserve. But, and so there are ways to do this, but I think you're getting the main point of what I'm trying to say to you here. I want to restate my thesis from the beginning. The design and implementation of federal policy and programs enables territories to survive, not to thrive, and perpetuate dependency. There are several root causes for this relationship. One is there's no congressional voting power, so you can't change the programs, you can't do anything. There's inequitable access to federal programs and opportunities, so even if you're doing things right, you're starting from behind with your shoes tied because you don't have the same resources. There's limited local capacity and expertise, more so in the smaller territories. I mean, the smaller territories are under 50,000 people, so I mean, the capacity is a real issue. There's no permanent coordinating framework along the federal departments and agencies, we discussed that. And there's no territorial advisors within the federal bureaucracy to advocate or advise. Now, the first three, those are very difficult, as you know, if not impossible. The last two, which are the ones I'm talking about, are very doable. But they're very doable only if we work together. And here's the thing. Every territory believes that they're special. And Puerto Rico is no exception. I remember hearing a woman in the radio say once, and I always stayed with me, that people in Puerto Rico think that they're the belly button of the world. El ombliguito del mundo. Which, and in a way, we have 5 belly buttons, Puerto Rico being the largest one. So when they come to Washington, I mean, sometimes the Pacific sometimes comes together because they have some issues, but they kind of move through departments by themselves. Of course, they work with Interior, and they're just easy to ignore because the incoming that you have at the federal level is just, the lobbies, this and that. There are 50 states because there's so many constituencies that they tend to get lost and divided. They're conquered. It's not done out of maliciousness. It's just the way things go. The emails go to the bottom of the pile. The territories, they think they're special, and they are special, not denying them that. And they do not agree on status issues or citizenship. They're not all on the same page on that. But they have so much more in common than not. And that's where they should be coalescing. There really is a need to coordinate, strategize, and leverage their shared colonial reality. It's hard to ignore what's being done to us if the 5 of us show up there and make it a collective issue, not like my issue. And so they need to think, act, and speak as a unit. When a hurricane strikes, whether it's in the Pacific or the Caribbean, they should all demand faster federal disaster response together. When an administration waives the Jones Act because of the Iran war, they should all be asking for a change in the cabotage laws. When Congress debates health care and social spending, and this is the one that really gets my goat, is they should, I have to almost read it, they should ask why do territories who are vital to national security, who are the literally spear of the military's, the tip of the military spear of the United States, have to receive unequal treatment in terms of services and programs. It makes no sense. And that is something that's not debated. So that is, anyway, that's, I don't have to go into that. You understand what I'm saying. I want to end, before I keep sputtering. Let me check this here. How do I get this gyros? The arrow? There. Okay, I want to end this picture. Not everybody here, because we have here from people from different places, do not know this picture. It's a famous picture. In 1898, we signed the Treaty of Paris, and it was signed by Spanish and American representatives. And there was nobody there from the territories. The following year, 1899, it was ratified by the Senate. And this delegation went to the Senate from the Philippines, Cuba, and Puerto Rico. And they tried to get in, and they tried to get their point of view across, and they were completely ignored. This is a picture of the men that tried to get into the room and did not get into the room. We do not need to repeat their history. Thank you.
So thank you very much to all the panelists who've provided us with a very broad and very substantive overview of the experiences that U.S. territories and tribal nations have that provide us with the background of commonality as well as the singularity that may exist among all of them. So you see that you have a QR code here on the screen. If you want to pose a question to the panel, please use the QR code to do so. If you don't have access to the QR code, feel free to use some of the pages on the program to pose your question. We'll be collecting them and bringing them to the panel. To get us started, and we want to have plenty of time so the audience can participate and engage the panelists, I will nevertheless start the conversation with a question for them, and I'm going to set it up. Implicit in this symposium on the U.S. territories is the goal of identifying the best analytical framework with which to study collectively the U.S. territories and their experiences. Since it's evident that the analysis of individual territories and the application of individual federal policy to U.S. territories has had the perverse outcome of leading to subpar results for the territories in question, whether it is by design or by default. It also seems evident that there doesn't appear to be a coherent or uniform standard for federal policy towards the U.S. territories. Pretty haphazard. Beyond perhaps political expedience. Yet the U.S. territories as well as the Indian nations are part of the federal system of government. We forget that. Federalism applies to the territories and to the Indian nations. They're embedded in federalism. But is being, and this is the question that I have for you, is being subject to Congress's plenary power the only ultimate standard to understand the territories and Indian nations within the federal system set up with all its variability and inconsistency? Or Alternatively, can you identify other frameworks, whether legal, political, or otherwise, that can help us analyze and address the relationship between the U.S. government and the U.S. territories and the Indian nations? So, who wants to take up that?
I'll give it a shot. Indian tribes have a relationship with the United States that obviously differs from that of the territories, and we usually call it the trust relationship, but in its original status, centuries ago, it was called the duty of protection. So that sounds better than it actually is. It's actually a creature of customary international law where a larger, more powerful nation takes a smaller state, vassal state, under its wing, so to speak, a nuclear umbrella even. And the founding of the United States, Constitution founding the United States, it was understood, there were examples of this around the world. We still have them outside of the U.S. There are things like Monaco inside of Europe and France, or the Vatican inside of Italy. They're actual nations with self-determination, sovereignty, that have largely, by virtue of a treaty, given up aspects of their external sovereignty in exchange for protection. That's the duty of protection part. From the bigger nation will protect the borders of the smaller sovereign. And internally, the sovereignty of the smaller nation remains plenary. We'll use that word. And so that's actually sort of, in a lot of respects, what the United States and tribal nations started out as. And that all became a big mess. And Gretchen pointed out how, this has led to dependency. In fact, the United States Supreme Court started using that phrase to describe tribal nations in the 1830s. And that's a big problem. But the interesting part about all of this is that the U.S. Supreme Court, in the original Indian law cases, we call them the Marshall Trilogy, named after a Chief Justice guy who used to own slaves, the court drew extensively upon customary international law to describe the relationship between the Indian tribes and the United States. And, they deviated from that in a lot of ways since then. But that international law still exists and has been modified and updated. And we've seen examples of the United Nations conventions, resolutions. I've pointed to the United Nations Declaration on the Rights of Indigenous Peoples for tribal nations. All of those things reference self-determination. And so those are sort of the modern day manifestations of what this duty of protection should look like. Now, tribal nations constantly fighting to enforce the duty of protection, whatever that might be. Many hundreds of tribes have a treaty relationship with the United States that sort of modifies the sort of baseline duty of protection. But these international law conventions, especially UNDRIP, really do enhance and give a sense of sort of modern understanding of what that duty should be like. The law is already there. It's actually in Supreme Court jurisprudence just long time ago. And I'm not as familiar with the insular cases, as they're often called, but my sense is that when you start a relationship like the tribal nations did, it was much more on a arm's length, equal footing relationship. I mean, the early treaties with the United States and Indian tribes were basically the United States asking for permission from the tribes, and the tribes had a superior bargaining power in a lot of respects. That wasn't so much the case with the territories, unfortunately. And I think when you start with a bad relationship like that, a weaker than position, you end up in a bad place. And the last thing I say, and I know you didn't ask this question, but I think something that Alvin said really hit me. There's that case from 1990 in the Ninth Circuit. The Supreme Court started to talk about Indian tribes in a way that's kind of creepy, which is the reason we have to have Indian law is because they might revolt against us, because we had Indian wars. And that creates like a perverse incentive to actually be violent toward the United States, which we don't want to be. But at the same time, if they're not going to respect our sovereignty, maybe that is what the Supreme Court is kind of saying we should do. And I find that troubling. But then again, what else does the Supreme Court say that's not troubling? So,
I'll say something quickly. In terms of frameworks, and I don't think this is like the framework, but I do think that we should consider race and empire together, right? Because I do think if we think of a framework, yes, Congress plenary powers over the territories and Indian tribes provides an adequate framework for thinking about commonalities, but we should not ignore or dismiss the importance of racism in the U.S. constitutional framework, political framework, and how that affects other communities who are not really subjected to Congress plenary powers in the same ways, right? So I think for me, like, race and empire is kind of like a commonality across marginalized communities. And then the other thing that I will say is that plenary powers is kind of like a short way, quick way to describe like a lot of things that they have in common. But and it's true that plenary powers is not included in the Constitution, right? But the Constitution does include powers over the territory, right? It also includes significant powers over Indian commerce, treaties, wars that have justified congressional power over Indian tribes outside of even the doctrine of plenary power. So I do think that what we should be looking at in terms of like a framework is what are, so again, some of the limits of the U.S. Constitution itself, right, in justifying and legitimizing a system of colonial power as well.
Anybody else would like to venture again? Final opinion.
Thank you. First of all, I just realized that I've been walking around with this stuff in my back. Sorry about that.
You're reserved.
Yeah, I am reserved. But I just think that, plenary power is extremely important doctrine, but it doesn't explain how federal authority is exercised or why, or the impacts that it produces on peoples. And so I also think that there are many other frameworks that are really critical. And so decolonization, of course, is absolutely important and gives us also a really rich vocabulary for identifying what we want to attain. But in addition to that, I also think that the political economy of colonialism is also another critical framework because it helps us to understand how the territories are used as basically a place to a captive market and a pool of labor, and also a place where we do not engage in productive economic development to sustain the economic vitality of our communities, and that produces significant vulnerabilities. But then in addition to that, the framework that I was using in my presentation is also one of saying, look, we also need to analyze and look at the actual impacts of the federal sources of authority on our families and communities and kinship networks to understand what is the on-the-ground impact of these policies. And I think that helps us to understand what the harm, we need to quantify and identify those harms as well so that we can act to specifically address them as well. So I would just add that.
Anyone else?
Yes, I would just wish to return to the obligation of the federal government under the United Nations Charter to advance the territories to the full measure of self-government. And the question then becomes, what constitutes the full measure? And this is where we are trying to determine, is it going to be complete decolonization or is it going to be colonial reform, which would not necessarily rise us to the level of, and this is why I mentioned some of the initiatives underway, which would effectively modernize the dependency, but are not bringing the dependency out of its place under the territorial clause and the plenary power of Congress, what have you. So the idea is, in fact, there are some alternatives to this, but it is basically rooted in questions of contemporary decolonization, referenda, particularly referenda that is not necessarily governed by the laws of the United States or federal laws. A primary example of that is the referendum in Guam, whereby the people voted through their legislative body to have a referendum on the basis of residency from 1950, which was the time of the Organic Act. However, this was contested in court, and it resulted in being declared a race-based determination. So as a result, that's where they are now, trying to determine how to deal with that. But the question is whether or not special electorates can be utilized for this purpose. They have been utilized in other places, and to determine the actual interest of the people in terms of their political future, to emerge into an arrangement that is of full political equality and not one that is lacking with democratic deficit.
Any other comments? Otherwise, I'll go to the audience. Do you have questions?
No? Okay, now it's on. Great. We have so many questions from the audience. It's great. Let me just sit here so that I can actually read them properly. I'm going to probably... Sorry? Oh, is it too loud? Sorry. Okay. I'm going to ask multiple questions at once, and then just let most are for everybody, some are for some specific folks on the table. So I think a more general one is, what mechanism exists for cross-territorial coalitions to create self-determination? And then I have one here that says, I've been thinking about the ways in which the territories exist in relation to sovereign nations in the archipelago, specifically Puerto Rico in relation to Cuba, in which Boricuas relate to Cuba, and as an example of possibility or peril. It strikes me that the current iteration of the U.S. blockade and destruction in Cuba is meant to instill fear and repression, just as our independence movements gain steam. In the contemporary moment, how do the panelists think we should consider other islands or in our imagined sea? And I'll just start with those and then bring it back.
The Cuba question is interesting. There has always been a desire for the territories to have some kind of agency at the regional level, both in the Caribbean and the Pacific. There has always been a tension with the State Department and the Department of Defense, particularly the State Department, who likes to keep its authority over any affairs having to do with international relations. So you have CARICOM, and I believe USBI is like an associate or observer thing, and then you have the PIF, which is the Pacific Island Forum, where the Pacific territories are also kind of observers, and they're always pushing to have more space in that area, but there is this tension. Now, I think they would make great representatives of the United States government because they are in the region, they're co-equals to people in the region, they know the region, and they could exert leadership. So I think there's a space here for a partnership with our Caribbean and Pacific territories on regional affairs, but the trust is not there. And so we're not going to pine any more on Cuba than we're going to pine in, I don't know, in Ethiopia. It's just, there's no space for that.
Don't mean to take the floor so quickly. Well, on the issue of international organizations and territories, I think there's a wide scope for that. It's uneven in terms of participation, but Puerto Rico, for example, belongs to CEPAL, the Latin American and Caribbean Organization of the United Nations, one of the 5 regional commissions. Now, depending on who's in office in Puerto Rico, it is either serviced or it's ignored. U.S. Virgin Islands, the same thing. We were very, very active in that CEPAL for a very long time until around 2006 when everything dropped. And again, it relates to who's in power. But there are other examples as well. And the CARICOM was mentioned. CARICOM has recently provided for participation of French territories, Dutch territories, but U.S. territories have not necessarily proceeded in that manner. But it's available theoretically. You have institutions in the Pacific, mentioned Pacific Islands Forum. These are Guam and American Samoa just became associate members of the forum, having had observer status prior. to that, but had not serviced it. Now, hopefully, they'll be servicing it. So you do have, and they also participate in the Economic and Social Commission for Asia and Pacific, which is the other regional commission in that hemisphere. So the idea of representation, in our view, in fact, is that we represent ourselves at these institutions, not in a proxy manner. And I think that's important because it also builds capacity for when we move to a level of full self-government.
If I could just add to that, though, as an associate, just because people don't know the lingo, you don't have a voting membership. It's an associate, so it's a lesser membership. The other thing is there are all these consecration of other allies, to Australia in the Pacific, to Japan in the Pacific, like who moves ahead of, allies in other regions. So it's not just letting the the territories be our representatives in these organizations, but it's also how does that play out with, people that we work in other regions of the world. So there's just that ongoing dance.
Say something very quickly about the second question in particular, which is that decolonization under international law is important, it's valuable, but it's not enough, right, to achieve meaningful decolonization. And in that way, part of this conversation, and it doesn't have to be the most important one, but if we're thinking about other areas in the Caribbean who are independent, right, but don't have meaningful independence, we should also be thinking about what is needed in terms of transforming international law and global relations so that even if states or colonies gain independence, they're not subjected to a position of neocolonialism and unequal structures of international law. So that also should be part of the conversation, right? How do we transform the systems of international law that are really, in ways, continuing some of the legacies of imperialism as well.
Any other comments?
Yeah, I'll just comment quickly and say that, in the context of 575 federally recognized tribes in the United States, we all have membership in the NCAI, the National Congress of American Indians, and it was actually created in, I think, about 1945 in order as a collective response to federal policies of promoting termination of the recognition of Indian tribes, federal recognition, and terminating the recognition of their sovereignty. And so it was born from a need for collective action and cooperation and sharing of resources to defend against federal actions that would have dismantled sovereignty and which did dismantle sovereignty for many tribes in the U.S. through that era. And so today it's NCAI serves a number of purposes, and one is that it's a collective organization that allows for representation before Congress and before the executive branches, but also it's an organization that allows for constant conferences and collaboration and sharing of experiences, the empirical realities of the effects of federal policies, their failures, their successes, and innovations that tribes participate in, so that can be shared and built upon, and so I think that that's an example of what tribes do in Indian country that I think the U.S. territories collectively. It sounds like there's separate organizations that they belong to, but I think that a model like NCAI could be very helpful.
I just wanted to add to what Alvin said about neocolonialism, because when I was talking about the Philippines, and we could say that the Philippines is completely decolonized, right? But is still dependent, like, based on kind of the neo-colonial forces, right? Winona was talking about impact on families, and you see that there's still this voluntary economic migration out of the Philippines. So that I think the question was, looking at these sovereign island nations with either as possibility or peril, but just to kind of understand that, regardless of sovereignty, the experiences of the residents of these islands are, can still be one of dependence on a neo-colonial system.
Wasn't there a question about organizations? Wasn't there a second question?
Well, the first question, I actually wanted to resurface that question.
Oh,
is
okay,
about,
okay.
collective action. What collective action can be taken by the components of the territories and perhaps also in the nations. And you, Gretchen, actually hinted at the fact that no, the territories by and large, they're going by themselves, and therefore they're more easily dismissed than if they were acting collectively. But what issue areas, perhaps, would be the ones that would be more apt to, engender this type of collective action, so that the territories can all, and I think that you suggested it also when it comes to natural disasters, etc. But are there specific issue areas in which the territories can all collaborate and lobby together before Congress or any other ally?
Can I add something? Just we have a question that I think matches up really well with this and could add further context, and it's about if Congress's power over the territories is absolute, and in this era of executive overreach, are there any limitations to the executive particular to the territories, which could illuminate a lot of what this question about organizing and coalition building among the territories?
I don't think there's any limits to what they can do personally, but in terms of area, things like geographic isolation, and what that means in terms of commerce, in terms of cabotage laws, in terms of import on food, in terms of disasters when there's a disaster. So they have that in common. Capacity building, their workforce and talent. Even in a place like Puerto Rico, we are having trouble getting talent. We're missing people in the medical field, people in certain fields that are, so that they have in common. All the social programs. I refuse to live in an island that can be eliminated in a military attack, and for them not to receive equal access to the same social benefits and programs. If you visit the Pacific Islands of Guam and the Northern Marianas, the one thing that strikes me there is how there's no physical history, because it was all bombed out during World War II. And so you go to this place and there's something faintly familiar. They have things like flamboyanes and so forth, and the vegetation and but it's just, when they talk about, their role in the Pacific, they're going to be the first ones hit. Why the heck can we not have equal benefits and social programs for these people? And the fact that this is not even an issue really incenses me. So, that is another area. Just starting things like capacity building, social programs, geographic elevation, and then economic development, because the problem is, since they're disenfranchised, they cannot sign up, they don't have a lobbying that goes to the senator, and then the senator writes in the bill that this place is going to go to them, And frankly, these places cannot survive without some form of economic intervention. So, I remember we really struggling because in the previous in the Biden administration, they were doing, we're exploring the idea of extending the sea moratoriums, basically. And the American Samoans were really concerned because of their fisheries. And we kept asking the American Samoans, if there's anything else you would like at this time, probably it's a good time to ask for this. Well, beyond the fisheries, we could not get, we could not get an answer. So we need to work to figure, okay, and I'm not anti-fishery, by the way, that was just the issue that was going on at the time, is, okay, what do we have here? What could we create? This could be a transport center, could be a this center, but we cannot just expect them to come with the ideas, because the system is not set up for their ideas. Kansas didn't say, I need a federal program and a federal office here, and it happened magically. No, there's a senator and there's a congressman that put it there. So does that, I'm sure there's more I can say, but that kind of...
No, that's pretty good. All right, so next question.
Okay, I have just a few minutes left, so I'm going to do sort of like a quick fire, especially with some questions that are specific to some panelists. First, Dr. Babilonia, can you explain the transformative agenda you referred to when you discussed anti-colonial solidarity? And then 2 questions for Winona. Can you elaborate on your framework, manage stability of belonging, as the one that can be enacted by internal agents of the Puerto Rican government, for example, but also how is this related to other legal regulations, such as the Cabotage Law 1920 Jones Act, and how do we need to quantify the effects of familial separation and displacement in efforts to regain or improve our rights, or is this furthering colonial justifications surrounding who deserves rights and what those rights are? And I have an extra question. Carlisle spoke about the one referendum that they've had in the U.S. Virgin Islands. I'd be really interested to hear more about how that was engaged, especially because in Puerto Rico we've had so many of them, right? And there is this sort of constant tug between statehood, the Commonwealth, independence, but also a lot of tribes have gone through that process of going through statehood, both Hawaii, and I can think of other states as well. If Winona or Matthew could also add some perspective on this sort of status debate. And I mean, and anybody really, because as Faye mentions, this doesn't end just by solving the status, right? Like this goes far beyond that. So I'd love to hear some about how each territory or group has managed these questions.
Whomever wants to jump in first. Rush to the mic.
I'll just jump in real quick. There were so many questions that I didn't get them all.
Can you give us a nugget, because we're all over the place?
Well, there was one about the Jones Act. I guess I would.
What about the Jones? Sorry. So Winona, really that one is about just elaborating on the framework of managed instability of belonging, and if it's necessary to quantify the effects of familial separation and displacement, sort of within that same framework. And then there's a question for Alvin about the transformative agenda in anti-colonial solidarity, and then I'm sort of adding this extra question about status and referendums and the question of statehood and independence.
And the last one is what happens after status? Is that your point?
No, just reflecting in, like, for example, like I'm not as familiar with the U.S. Virgin Islands and sort of what are the positions that are at stake in the same way that it is in Puerto Rico, but also with Indian tribes, how that process is sort of, because they didn't get an option for statehood, right? So sort of thinking about how that discussion has taken place over the different territories.
To be quick, so I see them as separate, the anti-colonial solidarity concept and the transformative agenda. I think anti-colonial solidarity as a vocabulary for how people make claims in the United States, being less reliant on constitutional arguments, and more reliant on these ideas of anti-colonial solidarities and racial solidarity in particular. And I do think that it connects to the transformative agenda as well, because I do think that from the perspective that I'm trying to develop here is that it's more likely that people will be able to mobilize around something that directly affects them, like a housing or land rights decision, right? And through that, they can build political power. So instead of thinking about decolonization from like this big picture concept, I think it would be better to think about it in a more local way and how people can build power together, and then through that have a transformative agenda about certain concrete policy goals that they might achieve at their local level. Right? So that's how I think about those two things together.
Yes, on the question of the 1993 referendum in the U.S. Virgin Islands, I was a member of the commission that put the referendum in place, although the legislation was given to us by the legislature, which had created 7 options, which of course is very difficult to advise people on 7 options. When we saw it, we tried to categorize them into 3, 2 in one, 3 in the other, 2 in the third, but that only made it more confusing. The idea was, of course, statehood, but then incorporated territory, which was the transition to statehood. So the idea of having both in one, was unclear. One of the interesting things that related to Puerto Rico as well is the fact that we had a Commonwealth status option, which is the only option that was not provided for us a draft bill. And we wrote that one ourselves. We wrote it on the basis of Puerto Rico, on the basis of the North Mariana Islands arrangement. In the end, it was unclear. We also did not have the issue of voter eligibility, as is the case in Guam. We dealt with it on the from the perspective of the current, or at the time, the existing electorate. The result was 27.4% of the registered voters participated, required 50.1%. As a result, it was declared null and void, which did not stop some people from going out and saying we voted to stay the same. I would suggest that we reverted to the status quo. We didn't vote for it. That's pretty much it.
And I'll just jump in and say that, there are many federal statutes, including the Jones Act as just one example of a statute which was intended to promote economic opportunity and advantage for the mainland to the disadvantage of economic opportunity for Puerto Rico. And so as a result, what you see is less economic opportunity and higher prices, and then this broader pattern of creating an incentive for people to leave Puerto Rico, losing that ability to provide those connections for their family, for their support, in order to seek opportunities on the mainland. And so also what we see in terms of how we would attempt to measure that, there are multiple ways, but if you look, for example, at the demographics, you see that there are significantly larger numbers of folks who are older than retirement age, but you see, a smaller population of individuals who are in that age of adulthood where they're working, who have left for other opportunities on the mainland. And then, of course, you see, elderly people who don't have the ability to have support from that extended family, and also less access to healthcare and less access to social services, and so significant impacts across the board. But I don't think there's time to go into more detail, but there are lots of ways to quantify that.
Yeah. Last word, Rachel.
I'd like to go back to what Alvin said. I think he's really right. You need a catalyst for this kind of for them to move forward. So when he's talking about housing or land rights, in the Pacific right now, the big issue is deep sea mining, and the fact that they're not being consulted at all. It's beyond. They want to sell the leases without any consultation. It's really atrocious. They're being unifying around that particular issue. In a place like Puerto Rico, there's a lot of unity these days around land rights, the use of ecologically protected lands for economic development, again without any consultation, and making it very easy or very difficult to counter these developments. So I do agree with him, but I just want to mention something. I think we also need to learn how to be kind to each other and good to each other, because particularly in a place like Puerto Rico, people are so polarized that they cannot talk to each other, such that if you say anything that's anti-established, that makes you immediately a communist or some ridiculous thing. And it goes, and this moment you say you like statehood, you're like some fascist pig. We have got to stop. Nobody can be 100% right or wrong the whole time. Somebody's right at times and somebody's not. And so to move these things forward, particularly in a place like Puerto Rico, we have to learn to be kind to each other. And the last thing I want to say, there's a group of people here which I follow these things closely. It's your only organization I know. It's called Right to Democracy, and they're the only organization that I know that is working on the territories as a whole. They do education, they do advocacy, they do litigation, and they do ecosystem building, and they're around here. They can identify themselves later, and they can tell you about their organization. We need more organizations like them, and we need people to focus more on these type of initiatives.
And with this, we close this session, this plenary session. Thank you, Representative Católica, Carol Corbin, State Chairman, Alvin Padilla Babilonia, Winona Single, and Matthew Fletcher.